Okay, we've got other folks
More folks
joining.
have joined, yes. So if we need some audio and video turned on here in just a moment.
And just as a note, if you see me looking around like this, I'm not being distracted by anything else. I've just got three screens in front of me, so
Oh, no
I have
problem.
to scan the whole thing.
Hi, to the person who's called in from the phone number ending in 1408, do you mind letting us know your name, please?
Miles McEachran.
Okay, thank you.
Were you interested in testifying later, Mr. McKeithran?
I wasn't planning on it, but just in case.
Okay, I'll check back in with you. So it looks like you're also maybe logged in on your computer. These are the same person, it looks like.
That's correct.
Excellent. Okay, we'll check back in with you later. And then, Sarah, do we know who Council One is?
Yes, that is our tech person, Tim. He is recording and live streaming our meeting.
Okay.
Since most public hearings are made viewable, live viewable on our YouTube page.
Okay. And then, Ray, you're representing the city today?
I am indeed.
Excellent. All right. Well, I'm showing that we're past the 10 o'clock hour, Sarah. So if you want to start the recording.
Sounds great. I will do that, and then I will turn the camera off. So thank you, guys.
Thanks, Sarah.
This meeting is being recorded.
Okay, get my gavel out, make it official. And good morning. I'm going to go ahead and call this session of the City of Oak Harbor Hearing Examiner to order. For the record, today is June 2nd, 2021 at 10 a.m. We have one item on our agenda today. This is number VAR 2101, a request for variances from several setback and parking requirements of the municipal code to allow the development of 5 standalone single-family cottages and 1 duplex building for a total of 7 multifamily units on a 0.34 acre property at 476 Southeast Barrington Drive. The requested variances in each instance would be necessary in order to allow development of the property while simultaneously protecting the critical root zone area of a Gary oak tree on an adjacent property. My name is Andrew Reeves. I'm a hearing examiner with Sound Loss, who the city has selected to hold certain land use application hearings like this one. And today it will be my role to collect evidence in the form of exhibits and testimony to determine whether this proposal complies with the city's comprehensive plan, zoning ordinances, critical areas ordinances, and the specific criteria for approval of a variance under Section 1966-020 of the Municipal Code, and in conjunction with the Gary Oak Tree Standards in Section 2016-030 of the Municipal Code. To that end, I received 4 exhibits in advance of the hearing today that I have had an opportunity to review. Those include the application materials, information on the environmental review that occurred in relation to this project, as well as some comments that were received from, I believe, Department of Ecology and the Department of Archaeology and Historic Preservation. I also received a staff report prepared by city staff and information about the notice that went out in relation to the application in today's hearing. So I'm going to go ahead and admit those 4 exhibits into the record. I'll go ahead and also admit the staff report, and we'll make that exhibit 5. But should anyone have additional exhibits they'd like admitted into the record, let me know when it's your opportunity to testify, and I'll go ahead and address admitting additional exhibits at that time. Speaking of testimony, all testimony today will be under oath or affirmation. That's because were my decision to ultimately be appealed under our state's Land Use Petition Act, the recording of today's hearing, as well as the admitted exhibits and my decision would serve as the foundation for any such appeal. Finally, the order that we typically follow, and I believe we'll follow today, is first I'll swear in city staff who will give an overview of the proposal and any recommendations that staff may have. Then I'll turn it to our applicant group to present any additional information they feel that myself or members of the public should be aware of. Then I will see if there are members of the public interested in testifying, and if so, we'll unmute you and give you that opportunity. And then if appropriate at the end, I'll turn it back to the applicant and city staff to respond to any such testimony. So that's the basic order. I thank everyone for being here. And with that, I think we can go ahead and get started. And I'll go ahead and get Mr. Lindenberg sworn in. Mr. Lindenberg, do you swear affirm to tell the truth in the testimony you give here today?
I do.
Great. Thank you for being here, sir.
Thank you for having us. I'm just going to kind of go through a brief overview of what's in the staff report. We don't have any new information to present today. Everything that we've included in there should cover all of the specifics that we need to talk about today. So I just wanted to touch on kind of the request itself and how it relates to our code. As you know, the section 21.16.030 refers specifically to variances for properties that have a Gary oak tree on them. And our interpretation of that, it says in the code that, if you have a Gary oak tree on the property, but our interpretation in this case is, although the Gary oak does not root itself in this property, it does affect the property through its critical root zone. And the drip line is the more kind of common terminology for that. And so we feel that this has the exact same effect on the property, whether or not it's rooted somewhere else. It does have roots underneath the property, which do affect it in a way that we feel that the variance can address. And so what the applicant has requested here is reduction in setbacks, specifically to have a 15-foot south or front setback, which goes down to 10 feet for an attached front porch. We do allow for that. The typical requirement is 20 feet. We can reduce that to 10. A rear setback of 15 feet instead of 25. Again, we're taking 10 feet off of that, which is allowed by the section 2016. And then the side setback is typically you have a total of 20 feet with a 5-foot minimum. So in practice, that works out to a 5-foot setback and a 15-foot setback. They're requesting 2 5-foot setbacks, which again meets the standard by allowing for a 10-foot reduction. And then the final variance request is to reduce the parking count down from 11, which is the typical required for a 7-unit project at 1.5 per unit, down to 9. And we feel we can support that. It is in an urban area, which will allow for more walking and use of mass transit. There's a bus line that goes right outside the front of the parcel there on Barrington, southeast Barrington Drive. So we don't feel that there's a concern with that. Now, specifically, we have the 5 variance criterias. The first one being the special conditions or circumstances exist on the property that are not essentially the fault of the owner, or it deprives the property owner of rights commonly enjoyed by other properties similarly situated. And as we noted, that there is this Gary oak tree that overhangs a significant portion of the property. You can see in that first, attachment there with the staff or with the applicant's material has the site plan on it. You can see the drip line, you can see the critical root zone, how much it impacts that area. If that were not there, we would not be discussing reducing setbacks and everything, because there would be plenty of room to put the 7 units on the parcel. Now, the restriction, the construction of the area constitutes a special condition that is particular to this parcel of land based on that Gary oak tree being there. And the code 2016-030 specifically references setback and parking variances to ameliorate the impact of this chapter, and that chapter being the Gary oak protection section of the code. Now, number 2 is the special conditions don't result from the actions of the applicant. Clearly, that tree has been there for a very long time, probably before the city was even platted. probably before people started, farming and developing the area. So this is clearly not anything that the applicant has done. Number three, the granting of the variance does not amount to a rezone. We feel that is definitely not the case. In the R4 zone district in which this is located, the typical density or the required density is a minimum of 4 units with a maximum of 7. If this tree was not here, they would easily be able to fit 7 units on there, and we're not granting any additional units by granting this variance. We're just allowing them to do maximum density, which they would be able to do otherwise without too much issue if that tree were not there and the variance were not granted. Criteria number four, the variance will not grant the special privilege to the subject property, which is denied to other lands. This will not grant them any special privileges. Like I mentioned, they're requesting 7 units, which is an allowed use and allowed density in the zone district and on that property. And number 5, the granting of the variance will not be materially detrimental to the public welfare, injurious to property or improvements within the vicinity. We feel that this is actually a benefit to the public welfare by allowing that maximum density. We're currently in a pretty significant housing crunch. So to be able to provide 7 units and that maximum density is a net benefit, we feel, to the community. It's an area where we like to see that higher density because of its proximity to services and community services, commercial areas, bus route, etc. There's already all of the typical improvements such as utilities, sidewalks, streets, all that sort of thing. And then we also get to protect an existing Gary oak tree. This is one of the larger trees in the community, and we would definitely want to protect it to the greatest extent possible. And so this variance would allow those two things to exist in harmony, the increased density or the maximum density of the zone district, along with protecting that Gary oak tree. So we view the proposed variances as a net benefit from that standpoint. And so our recommended action is to conduct the public hearing and approve this variance subject to 4 conditions. Number 1 being it's in general conformance with the plans submitted, which is a typical condition that we would include here. And then we have as a mitigation to the reduced setback that the area between the proposed buildings and the property lines be landscaped to the standards that are set forth in our code, except where an existing driveway and retaining wall exist, and that's also shown on the site plan. They have submitted a landscape plan to us, which looks like it meets those standards, and staff will review and ensure that is the case. And then number 3, all recommendations for protection of the Gary oak tree itself, as shown in the attached arborist report, are followed. And then number 4, just to note that the staff will review the site plan, landscape plan for conformance with the variance request and approve as set forth as a type 2 review process. If this was not a variance request, we would be going through the type 2 landscape and site plan review if the tree wasn't there. So that's kind of our typical standard process for that.
Okay, did that conclude your opening remarks, Mr. Lindberg?
That does. I don't have anything else to add. Thank you.
Great. I do have some questions before we move to the applicant. You had run through the sort of allowed density in the R4 zoning district. Had you already done the math on what the maximum and minimum would be? Because it's 12 units per gross acre as a minimum up to 22, but this is 1/3 of an acre, so you would divide it. Is that the math
Correct.
that happened?
Yes,
okay, just making sure.
Sorry, I did not explain that. Yes.
No, it's okay. When you said 4 to 7 units, I was like, wait a second, this is how big is this lot? So, okay, I understand the math that happened. And then just to be abundantly clear, I think you touched on it right at the end there. Normally, if we weren't here for the variance process, this would be an administrative review process with site plan review by staff, because this is not a subdivision of the land. This is essentially multifamily housing, but we're going to keep one parcel of land. We're not dividing the land. Is that accurate?
Correct. Yeah, and our code has been interpreted in the past that if a developer is providing the number of units, then we don't concern ourselves too much with how those units are oriented. Essentially, if they're in a single building or in multiple buildings, it's still a multi-family project. And so, yeah, it is a type 2 site plan review.
Right. But I mean, if the land is subdivided, then we have to deal with RCW 5817-110 and
yes,
all those things that are not at issue here, just to
correct.
be fully clear. Okay. Okay, we already talked about this is the type of development and density that would be allowed outright in the zone. You already covered that. I note that we did receive some comments on the SEPA MDNS determination, and you had talked about that briefly. My understanding, though, is because of maybe the holidays and a few things, the SEPA comment period technically ends June 4th. Is that your understanding as well?
That is correct. Yeah, that was, like you said, with holidays and noticing and getting to the paper and everything, we are just asking an official determination of your decision on this be held off until that date to make sure that we don't have any comments or appeal from the SEPA, and then we have to go back through a whole process again, which we can't do, honestly, by our code. And so assuming we don't have any comments or anything that comes out of the SEPA, then we'll just move forward. If we do, then we'll address that as they come in.
So that's what I was going to suggest. So I will leave the record open until the end of the day. Today's Wednesday, so it'd be Friday.
Yes.
And then Monday, staff hopefully just says no further comments, no appeals. Then we'll close the record. Technically, if there was some reason we needed to reopen the record, that would be allowed, should be allowed, because it's not a new hearing, it's a reopened hearing.
Correct. Yeah.
But I think that would make the most sense, and that you concur with that approach.
Yeah, I agree with that. Just let me know what you need from us from an official notification standpoint that there aren't any further comments.
Just email to my office is all that would require. And then in terms of SEPA, I believe that the DAHP, or Department of Archaeological and Historic Preservation, did suggest that some kind of archaeological report occur. Did staff look into that or have any thoughts on that? It's certainly very common to require an inadvertent discovery plan. And sometimes you see, staff has better knowledge of particular locations in some instance than the statewide agency. And, so I guess my question for you is, in your view, would a full archaeological survey sort of be necessary on a property like this, or would an inadvertent discovery plan be sufficient?
What we did on this is our SEPA MDNS, the conditions of approval on that just state that the applicant shall abide by the recommendations and conditions of the Washington State Department of Archaeology and Historic Preservation letter dated February 24th. So they're going to need to go through with, and follow those recommendations of DAP. In answer to your question, it is a high-risk area, so it's probably a very good idea.
Okay, great. So that's already included in SEPA, and then we've gone back and forth over the years, but I think my office has come to the conclusion it's best to include an additional condition that says the applicant shall comply with the requirements of SEPA, because technically, SEPA is an independent process. And so if it's not a requirement of the permit itself, it can get lost in the wind. So we would likely add that condition as well. Okay, I think, and what is your official title at the city, Mr. Lindenberg, just so I have it? I've written a decision where you were presenting before me, so.
Yes, I'm the associate planner.
Okay, great, thank you. Great, well then I believe those, you have answered the questions I specifically had. I thank you. So at this point, why don't we turn it to our applicant, We've got Jay Dinsda here. Mr. Dinsda, I'm going to swear you in. Do you swear or affirm to tell the truth in the testimony you give here today? And we need to unmute.
Yes, sir. What do I supposed to say?
Yeah, you're good. So you're
Okay,
both
thank you.
sworn in, but I'll have you speak one at a time. So thank you for being here, Mr. Dinsda. This is your opportunity to present any additional information you feel like you want me to know about the project.
No, I don't think so. I have anything. Yeah.
Okay, no additional information right away. I guess a couple questions for you. In your mind, is there a time frame you're hoping once you have the permits when you would begin moving forward in your mind?
We are ready right now.
Okay.
Yeah.
So often with these permits, there's specific, you kind of get the permit, and if you don't lose it, or sorry, if you don't use it, you lose it. So you're ready to go as soon as.
We are ready to go, yes.
Okay. And then have you reviewed the MD&S from SEPA, the mitigated determination of non-significance? And do you see any issue with complying with the mitigation measures?
I saw that. I don't think so. We have an issue.
Okay. And then staff, Mr. Lindenberg, in his staff report recommended several conditions of approval for the permit. Did you review those in the staff report, and does that all make sense to you?
Yeah.
Okay. Okay, well, again, the questions that I had, Mr. Lindberg already answered, so I don't have any further questions specific to you. So what I'm going to suggest is we had one member of the public that called in. We'll see if they have any testimony they want to provide. If so, I might call on you again to respond. If not, we'll likely be able to wrap the hearing up. So at this point, if we can unmute Mr. I think it's McKethrin. I might have mispronounced that.
Oh, Miles McKeithron. I'm the project engineer.
Oh, I'm sorry. I thought you were a member of the public. I misunderstood earlier. So, Mr. McKeithron, did you have, as the engineer, any further thoughts or comments you wanted to share?
I do not.
Okay, well then, thank you for taking the time for being on the call. I just happened to not have any specific engineering questions that I needed addressed. So I think then we are all set in terms of public testimony. There are no other members of the public, I believe, that have joined us. So at this point, Mr. Lindenberg, on behalf of the city, do you have anything further you wanted to put on the record or discuss?
No, I think we're good. Thank you.
Okay, well then, as I explained earlier in our discussion, we do have this little issue with SEPA. We're going to leave the record open until the end of Friday, end of the day Friday. And assuming nothing else happens, which based on the record thus far, I would expect it's unlikely that we're going to have further comments, but just to be safe, this is the most prudent course of action. City staff will then inform my office, and you probably want to inform the applicant as well, that we can close the record. So the record will then close, and my office will issue a decision within 10 working days of the record closing. So I'll take everything I've seen into consideration, and once the record closes, I'll produce a decision, like I said, within 2 weeks of the record closing. So I believe that's it. I thank everyone for taking the time to be here to answer my questions. I wish everyone safety and good health as we're hopefully near the end of the pandemic, fingers crossed, and enjoy the nice weather that we're having. And I think with that, we can end today's meeting. Thanks, everybody.
The recording has stopped.